I think we're all ready. Have a seat, please. We'll begin with PAPPALARDO versus Building Code.
Building Code.
May I have a seat, right?
Yes, please.
Yeah, he confused you with the be seated, right?
May it please the court.
Line up in a circle, you know.
In alphabetical order.
Pair up in threes.
May it please the court again. My name is Darren Elkind. I'll be referring this morning to the Building Code Administrators and Inspectors Board, the state agency, and the respondent in the proceedings below is the board. They have created a policy. It is a bright line policy, which requires specifically 10,000 of hours of full-time employment in a specific trade. It precludes an applicant who has garnered the statutorily mandated experience from making application to be an inspector in certain trades or from taking the test. The statute says that an applicant who wants to qualify through experience, there are other ways to qualify, but the relevant issue in this case is one who qualifies through experience, which is, as the record shows, the predominant manner in which building inspectors qualify. They must show that they have 5 years combined experience in in construction or related field corresponding to the category sought. If I may, I'll digress it for a moment. I argued in the brief the last antecedent rule, and in fairness, I will confess to you that the rule would literally dictate that it only applies to plans examiners. It doesn't make walking around sense, and we'll just give up on that argument. I think even for somebody who's got their experience through working in the construction industry, it has to relate to the category being sought. But they have a policy, and there's no question or dispute that they have a policy. It was very well laid out by the board's chairman at the hearing before the ALJ, how the policy works. And that policy requires, as I said, 10,000 hours. The policy imposes a requirement vis-a-vis 10,000 hours, 5 years, specifically as, we'll use the example of a plumber, as a plumber, to the exclusion of any other construction-related work experience in order to sit for the exam. Take example, and there's two ways that's problematic. Take, for example, a plumber whose only job is a plumber. And he's worked for the last 5 years as a plumber, but from 2007 to 2010, he's only working 30 hours a week because of the economy. Clearly has the experience, could go before the board, could pass the test, could show that he's got the experience. He's worked as much as he could as a plumber. Their rule would prohibit that person from becoming certified. It's a bright line policy. More importantly, what their rule precludes or prevents, it's not a rule, it's a policy. We argue that it is in fact a rule which has not been promulgated. Their policy precludes someone who garners their experience through work as a general contractor. Mr. Pappallardo, for instance, had over 20 years experience. There wasn't much dispute that he knew plumbing, did plumbing, knew mechanical, did mechanical. But yes, sir.
As I understood it, he didn't really lay it out that well in his application, did he? In other words, where he was able to identify those periods of time when he was doing plumbing or whatever.
He did not.
It was more general, wasn't it?
His experience, the things that he did, the types of work that he did, he laid out, in my opinion, very clearly, and I think that was clear from the record. What he did not do was add up that he had 5 years of hands-on in this or 5 years of hands-on in that. Yeah. There is a rule which requires 1 year of hands-on experience in whatever the trade is, and the state provides no explanation for the obvious conflict between the adopted rule and the statutory provision. But this policy, it precludes, as a matter of policy, an applicant who has worked at a GC who can show that as a GC he's done it for more than 5 years and has the requisite experience as provided for in the statute and prevents him from even being able to come to the board and show that he has that experience. Would not be able to come and be questioned by the board. I mean, this policy vitiates the very purpose for which the board was created.
Because he has to go before this 3-person screening committee or something?
He doesn't actually get the opportunity to go before that committee. As we learned in the hearing, this application review committee, he was not notified of the application review committee. The ALJ found that there was no legal requirement that he be so, although not an issue before this court. That's obviously incorrect. The Sunshine Law clearly would make that a public meeting and clearly require notice to the applicant. He was not afforded due process. But even, that's not an issue for this court. Even if he had been given notice, even if he had been given notice of that application review committee meeting, they have a policy, and they would not have allowed him there, nor would they have allowed him at the full board meeting to go have due process, to be able to explain, here's what I did, here's how I am qualified, here's why I am qualified, because they have a policy that says unless you have worked 10,000 hours, I mean, it was very clear in the transcript, I can cite it. Unless you have worked 10,000 hours, for example, as a plumber, to the exclusion of any other work during that time period, you may not become certified.
I guess I can understand the policy there. I mean, I can understand, for example, that if you're a general practitioner and you decide you want to become board certified in neurosurgery, that the fact that you're a general practitioner for 20 years and you know something about neurosurgery doesn't necessarily make you qualified to be a neurosurgeon. I mean, I can understand that general policy.
Sure.
The implementation, I guess, is a bit troublesome here.
Absolutely. And it's a bright line policy. It's a rule. And if we look at the definition of a rule, it's in 120.5216. They actually define a rule, and I'll read just the relevant portion. A rule is defined as each agency statement of general applicability, which this is. I mean, this is their policy, that implements, interprets, or prescribes law or policy, or describes the procedure or practice requirements of an agency, and includes any form which imposes any requirement or solicits any information not specifically required by statute or an existing rule. They have made this policy up. It is not found anywhere in the statute. It cannot reasonably...
Where does it come from? I mean,
it's arbitrary.
Isn't it 2,000 hours a year times 5 years? I mean, isn't that where they get it from?
Yes, Your Honor. That's how they did the math to come up.
They're trying to prevent the occasion where somebody works 1 hour a year for 5 years and claims that they qualify. Isn't that what they're trying to do?
That may be what they're trying to do. That is not what they have done.
Well, what does 5 years mean, 5 years experience?
It means you have, the reasonable interpretation is that you have worked in the construction field for 5 years.
On a regular basis.
On a regular basis, I think, yes.
Full time, right?
Yeah. I don't think the full time is necessarily problematic, but a specific finding of 10,000 hours is problematic. A specific policy of 10,000 hours is problematic. Moreover, they will not allow, as part of this policy, they will not allow somebody who has gotten their experience, regardless of whether they are qualified. Mr. PAPPALARDO passed the test, because you can take the test without being certified. They will not allow someone who's garnered their experience through working as a general contractor to sit for certification in plumbing, mechanical, or electrical. You could be a helper. It's a silly example, but you could be a helper for a plumber working in plumbing for 5 years full-time, 10,000 hours, and you automatically meet their policy. And no far less than somebody who has got a significant amount of plumbing experience working as a general contractor or for a general contractor. The problem is this. It's really akin to a due process issue in that there are folks, to use Your Honor's neurosurgeon example, there may be somebody who has been a GP, a general practitioner, to use Your Honor's example, who is fully familiar through that practice because he's done orthopedic surgery the whole time and wants to get certified in orthopedic surgery. The point is, the person is entitled to, if they meet the statutory requirements, to go before the board and have a full hearing before the board and let the board, the experts, decide whether or not they, in fact, are qualified. That's the reason the taxpayers pay so much money to operate this 9-member board. This bright light policy can be applied by a clerk sitting in office. They don't need a board of people with expertise to review the applications. In fact, they're not, but because of the application review committee. But in any event, if we look at the very definition of a rule, this policy clearly and squarely meets the definition. It is so quintessentially an unpromulgated rule that if it is not, I could not imagine what would be an unpromulgated rule. I will reserve the rest of my time if it pleases the court.
All right, thank you, counsel. Hear now from the building code administrators, et cetera.
May it please the court, my name is Tim Dennis, Assistant Attorney General representing the appellee, Florida Building Code Administrators and Inspectors Board. The first thing I'd like to do is address a couple of the points.
Would you get to the 10,000 hour thing? Because I think that's a very interesting.
Yes, sir. The record, Your Honor, I think that we disagree about what the record actually reflects, and I would actually turn your attention to page 66 of volume 3 of the which is the transcript of the hearing, where specifically the witness rebutted the contention and said, the question from Mr. Elkine, you indicated that there in your testimony that a person is, what you're looking for is 10 years in the case of 2 trades divided by 2, and that they would have, I believe he said, 10,000 hours dedicated solely to the specific licensure being sought. If I understand you, and correct me if I'm wrong, but if I understand your testimony correctly, what you testified to is that you are looking for 10,000 hours if a person's working in nothing but, for instance, if it's plumbing, only in plumbing. During that 10,000 hours, they could work in no other field besides plumbing. Am I to understand what you said? Answer, no. What I said, and it was an effort to put this in the simplest terms so that everyone can understand it, we require a year of experience to be the equivalent of a year of full-time experience. So, and the ALJ agreed and said, look, this was simply an illustration by the witness to break it down, but they don't sit there with calendars or calculators or do math when they're determining these things. But the board, the plain application of the statute says you have to have 5 years experience, and it's our position that 5 years experience means 5 years experience, and that is the requirement of the statute.
5 years experience in that specific.
And it's corresponding to the category sought, and Mr. Elkind agreed that to interpret that statute otherwise doesn't make a lot of sense.
Right.
The second issue is that he raised the issue about the application review committee and that he should be able to come forward and have a hearing. I think I pretty clearly addressed that in my brief. But no other applications, if a person applies for a license as a massage therapist or a license as a cosmetologist or a license in another trade, it's not clear from the record, and in fact what the testimony is in the record is that they think the meetings are noticed as public meetings. Now, does the applicant receive an individual notice? No. But as the record reflects, the applicant gets either a license or they get a notice of intent to deny. And if they get a notice of intent to deny, they have the right to a 12057-1 hearing before an ALJ, which is what Mr. Pappallardo requested and had, or they can have a 12057-2 hearing where they can come before the board and explain a little bit more and try to, justify their right to a license. So I don't think that's a violation of due process.
Counsel, do you agree that the Hardin case, the 2009 case out of the First District, pretty much suggest that the use of those review committees is improper?
No, I don't, Your Honor. What I think that case suggests is that it's improper without a rule in place.
Yeah.
And since there's no other authority out there in the court, although the board disagrees and thinks there's good legal reasons for disagreeing with that opinion, as we set forth in the opinion, we have a rule in place. We've adopted a rule now for the application review committee process. But more importantly, that was harmless error. He had a right, he had a hearing before the ALJ. He could have put on whatever evidence he wanted. He just rested on the application.
Where? Where could he have put on his evidence?
At the administrative hearing before the administrative law judge.
He chose not to, correct?
He chose
relied
not
on
to.
the record
He chose to just submit his applications and rest on his application.
I thought, yeah.
Okay.
Didn't present any additional evidence or testimony. So the most important point is that the board's construction of the statute, I think, it says 5 years combined experience in construction or related field, building code inspection, or plans review corresponding to the category of certification. It's our position, and I want to amplify this point because it may not have been made clearly enough in my brief, is that we think that is the plain and ordinary meaning of the statute, and therefore a rule isn't required. I mean, what are you going to say? And I think that the case of...
Is there a form for making an application? I take it there is.
There is an application form.
Does it say by hours, or how do they do? Or they just say?
There is a section of affidavits which you can reproduce.
That's how they do it.
And they're by month and year. It doesn't ask for hours.
Right,
the hours is a red herring.
Yeah, that's what I thought.
I filed a notice of supplemental authority, matter of Waldron yesterday, and I think the court clearly said that a similar provision in law as applied by the state fire marshal was entirely reasonable and within the authority of the state fire marshal. Now, it's important to note, the question before that court was not whether the state fire marshal had to have a rule to implement that. They did have a rule, so I'm not conceding that we have to have a rule, but I'm just for the point that to require 5 years of full-time experience. Now, could it be problematic in some instances? It might be, but you have to try to set up a fair process if possible, and it may or may not always produce the most correct result, but in most instances it's going to produce the right result. In conjunction with that argument, Mr. PAPPALARDO raises several sub-arguments, and the other argument I want to go to again is he also brought up the issue of the rule, and that's 61G 19-6.00351C. And first, I want to repeat in my brief, but I don't think I expressed it clearly enough. We don't think that issue was preserved for appeal. Yes, Mr. PAPPALARDO put in his brief, in his recommended order in his brief, part of that rule. He put in 1B, and he cites to it where he says, I put in the affidavit, so I've met my evidentiary burden. He made no specific argument regarding the application of Rule 1C, which is a rule that states all applicants have to demonstrate 1 year of hands-on experience. In Florida, emergency physicians, Kang versus Parker clearly says, 5th DCA case says, the court shouldn't consider matters unless it's jurisdictional or fundamental that could or should have been raised to the trial court but weren't. And even if the board does consider it necessary to consider that rule, first, it's not inconsistent with the statute, and the board didn't deny him on the rule. In the notice of intent to deny, it only cites the part about the rule related to affidavits. It doesn't say anything about he failed to demonstrate 1 year's experience. And that's not clear from the record even. There's no finding. The judge noted in her ALJ, neither party noted that rule. or addressed the application of that rule. But even if he had, he wasn't denied on that basis. He was denied on the basis that he hadn't met the 5-year statutory experience. He also says the board has a policy that it won't accept general contracting experience. Again, I think that slightly overstates the record of this case. But the board, in fact, did consider his general contracting experience, and there's testimony in the record about it, that they did consider his experience, and they considered it sufficient to issue him not 1, but 2 licenses from the board, a building inspector and a 1 and 2 family dwelling inspector's license. But that the evidence was either not sufficiently related to the specific trades he was applying for, or it conflicted with other portions of his application for which he didn't provide any explanation at hearing about. I think a couple of the other arguments are raised regarding the ambiguity in the statute. I mean, I just say that those provisions aren't at issue in this case, and I don't think it's clear that they make an absurd argument, and it's really not the board or Pappalardo's prerogative to second guess the legislature about what the requirements are. And in the one particular case where they say, well, a person could be a building inspector for 1 day and then take a training program, well, a person who's a building inspector for 1 day has already qualified through one of the other methods of licensure for at least 1 statute. So it's clear that they do have some evidence. And finally, just to hit on the third argument again. 1, we don't feel the due process argument for the Application Review Committee, we don't feel it was preserved. Secondly, the board, although it disagrees legally that it's required, it's gone ahead and adopted a rule. But the most important point is that it's harmless error. There was a full and fair opportunity for him to have a hearing. He had a hearing. The record, including his applications, the ALJ's recommended order, the transcript, all went back before the board, and they were able to make a judgment, the full board on the record. And so in conclusion, I would just point to you that I think to the Astral Liquors case cited in my brief, I mean, licensing it's a little fuzzier than some other methods, some other proceedings before a state agency. And if there's a question, you should defer to the agency which has the expertise to really, make those determinations. And if there are no more questions, I'll conclude my argument.
Thank you, Counsel.
Thank you.
All right, finally we'll hear from the appellant.
Thank you. The right to administrative law a hearing before the ALJ confers no right whatsoever when the ALJ enforces a policy of the board's policy. In other words, that's the issue here. Is we had the hearing before the ALJ, but she upheld essentially and found correct the policy of the board, which requires the policy that we've been discussing. And so it's of no import that you were able to go to the ALJ if the ALJ is upholding the policy. That's why we're here, for a statement of law that policy must be adopted by rule. You can't just enforce this policy, which is, if not arbitrary, certainly has no basis in the statute. So it's illusory and to suggest that it was somehow cured by the fact that you had a hearing before an administrative law judge who still upheld the policy. In Hardin, where they found the process to be improper, Hardin had a full hearing before an ALJ. ALJ found the procedure was improper. So I don't see how the fact that you go to the ALJ hearing, if the ALJ is still enforcing that same policy, cures the problem with the underlying policy. I think it's pretty clear in the record, and I don't think my brother at the bench would argue this point if he got back up, that they and I can cite you in the record where the transcript rather, where they do not, for Mr. McCormick's part, on behalf of the board, does not accept service as a general contractor for plumbing, electrical, or mechanical, regardless of whether the person is qualified. It is a bright line policy, a bright line rule. Yes, they gave him he had previously obtained a license as a building inspector because they find that general contractors can only, that general contracting experience can only qualify you as...
Are you saying that if he demonstrates that that he had a subspecialty, if you will, in one of the trades, that they're not going to give him a license?
Absolutely. That's absolutely what their policy does. No question about it.
Mm-hmm.
And I don't think, I don't think there's really any question about that. And the problem with this policy not being adopted...
Working as a general contractor doesn't necessarily give you a specialty in the trades. Right?
Absolutely. Not necessarily. Not necessarily. But what the policy, and that's my point, what the policy does is it precludes the opportunity for someone who's garnered their experience as a general contractor from going before the full board in demonstrating that they have the requisite experience.
If you're a general contractor who employs no subs and you build houses for 5 years, you're saying that they're not going to...
Absolutely.
The policy is unequivocal that they can't get licensed other than the general licensure.
Yes, Your Honor. Exactly. That's the problem. And there may be, to use Judge Monaco's...
You say that's clear in the record. Is that what you said? That's clear in the record that some witness...
Well, it was Mr. McCormick was the only witness, but I can go and
Well, I mean, you made the assertion that it was that your counsel, your opposing counsel,
No,
wouldn't refute it, right?
if I may have...
Irrefutable.
If I just may have a moment, Your Honor.
Is that true, counsel, what he said? Do you agree with that statement?
No, Your Honor.
Okay, well, he would have refuted it if he got the chance to get up here again.
I apologize. It's where Mr. McCormick says we don't want the general contractor. We don't want somebody who supervises. It's that line of questioning.
Well, to me, there's a difference between a general contractor that acts as a general contractor and employs tradesmen, subcontractors to do mechanical work and plumbing and things like that, and a general contractor who's 100% hands-on. I mean, in the old days, there were general contractors that built houses from the ground up. Is that the kind of general contractor that your guy was?
That's what Mr. PAPPALARDO was, and that's what the affidavit showed, what the evidence showed. And certainly there are GCs, especially the larger ones, who never see a job site. They're negotiating contracts, they're procuring loans, they're doing cost estimating. They have no hands-on experience. But the policy precludes someone who is a general contractor from allowing the board to even do the job that it was statutorily mandated to do, is to evaluate their qualifications. Therein lies the point.
All right, we'll look at that.
Does that conclude your argument?
Yes, Your Honor. Thank you.
Thank you very much.
Thank you all very much.
And that is our last case for this morning.